Let me start by getting a clarification.
Yes.
When you are being engaged on the issue of unconstitutionality of timelines in respect of historical land injustices, you rightly pointed out that that has been declared unconstitutional by a court. But you went ahead and brought in the AG. Can I understand how the AG comes in?
Thank you very much, my lord. I think the only reason that I had indicated the AG is because the Law Reform Commission would still largely fall under the auspices of the Attorney General's office, which then implements the changing of the legal provision. Because, like has been indicated, the National Land Commission Act as it is ought to be amended.
So, do you take the position that the declaration of unconstitutionality does not take effect until a law reform?
Thank you, my lord. No. The position of unconstitutionality will take place immediately the courts have pronounced themselves, my lord. The act of the law reform is a mere administrative implementation of the pronouncement of the court.
Yes, that is the clarification I needed. Thank you for that. Then, from a background, you worked at a TJRC as a director legal. You also worked at the NLC as a deputy director legal, and now you are the NET secretary. Now, from this experience, there is no doubt you have dealt with the question of historical land injustice substantively. Now, what type of injustices have come up within the coastal region?
Thank you very much, my lord, for that question. My lord, I always say that the issue of the coastal injustices have to be understood from its historical perspective. We are aware that at the time when the coastal strip was still known as the 10-mile coastal strip, which is what has demarcated the regulation of land in the coastal area, it was under the Sultan Zayed. And at this point, I always remember with a smile that the then Prime Minister, who was the President, actually leased that land at £16,000 a year. So when we did get independence, it was then when we yielded that land from the Sultan. And part of the conditions was that it will be regulated by law. This is why the Land Transfer Act was then the Land Titles Act was then instituted at that point. But that injustice in the coastal area emanates at that point because the coastal people were people who used to live freely. The introduction of the LTA brought about registration. Now, what it did, and when the Sultan was yielding the land back to us, is that the learned and the elite understood that they needed through the LTA to be able to get what they called the certificate of title, which was a prove and own. So you had to go and show the expanse of the land you own and then get a paper ownership. But you see, the multitude of the people did not understand this. There were people who used to live, and you will actually realize that the survey in the coastal area was also what we call general boundaries, because people would have what the Swahili call minazi, which used to mark their boundaries. And that worked very well within the LTA. But then when the elite got their titles, they left the country. Actually, they went to two countries in particular. They went to Europe and they went to the Arab. Now, they left, but they left with title documents. So they owned the land in paper, but the coastal people still continued staying there. Part of the conditions that the Sultan had given the then Prime Minister was that the coastal people will not be removed, will get a Qadhi's court so that we respect their way of life. However, the injustice in the writing was that they did not have the paper, and they didn't see the need of getting that paper. So we had people living there for years, but then now two problems came in. Number one, we started the absentee landlords at that time because they got paper ownership and flew out. Then we got squatters because then the coastal people would stay on this land but not have paper and not realize it.
Okay. Now, two problems, the squatter problem and the absentee landlord. How has NLC dealt with these issues?
So thank you very much, my lord. So the National Land Commission has actually addressed these issues in two ways. The first one is through the HLI hearings, whereby the law allows the commission to be able to go and look at these issues and to be able to correct it. So on the issue of absentee landlords, It has been dealt with both by the NLC and also by the Limitations Act. Adverse possession allows the people to be able to own the land, and a lot of the people in the coastal region are currently holding that land. Secondly, because of adverse possession and the efflux of time, because the people who owned this land had their rights extinguished after a given number of years. Secondly, it's of course by listening to these procedures, and as the law provides, we have recommended big areas of historical land injustice for it to be converted back to the people on the ground. And how has this been done? There has been two primary processes that have been done. One was when we went to the coastal region. This was during the first commission's tenure between 2012 and 2017. We were able to go and get title deeds given by virtue of someone being on the land. However, of course, as Kenyans are litigious, this process was challenged by the absentee landlords, so most of these processes are still in court. But currently, even as we speak, as Commissioner Omanza had indicated, that power and jurisdiction mandate was actually stopped because it was a timed provision. It was reenacted last year with the amendment, and so the commission has been able to go back. We just commissioned our new commissioners yesterday, so the first order of business is, of course, to go to the coast, having understood the background of the problem there.
Okay, so maybe in terms of scaling it up, if we give it a scale of 0 to 10, where can we say NLC is in respect of dealing with these issues?
Thank you very much, my lord, for that question. I'm trying to do the mathematical calculation, and I'd say, allow me to answer in two ways, substantively and procedurally. Procedurally, I'd say NLC is at 85%. Substantively, I'd say maybe 25%. Substantively to mean the actual effect, I'd put it at 25%, and which is also a systemic issue because they can only recommend. But procedurally, I'd put the National Land Commission at 85% because we have processes, we have guidelines, and those are ongoing processes.
Okay, lastly, did you deal with these issues under the TJRC?
Thank you very much, my lord. Yes, we did. I actually headed the team that went there, and I remember that the issue of documenting the historical land injustice and even appreciating that historical background came from the TJRC, where we actually dealt with the issue of historical land injustice and actually visited almost every part of the coastal area during my stint at the TJRC. And
what did TJRC recommend?
Oh, thank you very much, my lord. There was restorative remedial actions that were recommended by the Truth, Justice and Reconciliation Commission. There was, of course, the change of the law, and that's the point we are coming from the LT and we went to the RLA. So we're now trying to ensure that the legal and the regulatory framework at the coast is actually put at the same level as the one of the rest of the country. And if you may, my lord, I'll just put one of the biggest challenges at that point was that given the LTA system, that system, the regulatory system at that point, it is the hardest for you to be able to convert, even with the electronic system we have now. But of course, we did provide that the same system should be applied in coast, and that is what informed the Land Act and the amendments when it was now said we will have one universal and uniform system in the whole country. That recommendation came from the TJRC report.
Okay, so you think we're making any progress in resolving some of these injustices generally? Or it's at a snail's speed?
Thank you, my lord. I'd say we are making progress, and I'd actually put the bigger task at the judiciary and say that it is now behoven on the judiciary to help us move the procedural progress to the substantive progress, because NLC recommends, my lord, and if for us to be able to implement it, the bigger muscle would come from the judiciary. So yes, we are making progress, snail speed, but of course we can make it better.
Okay, I would have engaged you further on some other areas, but in the interest of time, thank you so much, and I wish you the very best.
Thank you, my lord.